Tim, thanks for joining me today.
Hey, thanks for having me.
Well, look, as a start, it'd be great if you could provide an introduction into yourself.
I'm Tim Foden. I am a partner at Boies Schiller Flexner, which is an American law firm here in London, and I'm an American. I've worked in London for 15 years. I qualified here by taking an exam which was called the QLTS, as it then was.
So, qualified legal.
Training transfer scheme.
Yeah.
That was 15, almost 16 years ago.
Yeah.
That signed up in a course, got some books delivered to my house, studied, and took some exams in New York when I was living in Washington, D.C., which made me what I used to refer to as a plastic English solicitor because I had the qualification. But at the time, you didn't want me reviewing or doing an English law dispute.
Yeah.
That changed when I moved here to work at Allen and Overy
Yeah.
after about 6 years of qualification in the United States. So I moved here in 2011 and very quickly got dumped into the deep end of not only investment treaty arbitration, which is what I primarily do now, but English law commercial disputes. And I remember saying to a partner then, hey, Mark, I haven't really done an English law case on like interpretation. I said, well, you better learn it. So I took home Chitty on Contracts and I read it every weekend. And,
Right.
and now I'm, much more au fait with doing English law contractual disputes than I am anything in America. I haven't practiced in America
It's been a while now.
since 2011.
Yeah.
So maintain my qualifications in Washington, D.C. I'll never be anything but a guy from Philadelphia, particularly in the eyes of the English. They hear my accent and doesn't matter that the fact that I'm about to approach, having lived in England longer than anywhere else in my life, I'll always be the American lawyer in London. And I'm fine with that.
Yeah.
But I am, by training in Washington, D.C., a courtroom litigator.
Yeah.
And what I've done for the past 15 years is just international arbitration, really. My practice and time has morphed into what I would refer to loosely as crisis management.
Yeah.
Clients end up with a problem in a foreign jurisdiction, and I help them with solutions. Sometimes I go there and negotiate with governments, get food poisoning, fear for being my liberty and getting locked up, get parachuted into situations. But it's a fascinating life. It's a really enjoyable one. And, when you get more senior as a lawyer, your job in disputes is to provide solutions.
Yeah.
And that's what Boies Schiller Flexner has always been known for. So when the opportunity came up to work at this firm a little over 4 years ago now, I jumped at the chance.
Great. So, going right back to the start then, you said off camera that you started off your legal career at Sullivan Cromwell. I mean, how did everything start out for you?
Yeah, so like I said, I grew up in the suburbs of Philadelphia, and my dad had gone to university, but he never graduated, and he, in his late 40s, became a house painter.
Yeah.
And then my siblings, who are all much older than me, they also went into the trades. My brother is a plumber. My other brother was a house painter. My sister was a PA, and my mom was a florist. So there was no experience of office life really for me. And I went to a school called George Washington University. I wanted to work on Capitol Hill in Washington, D.C., where a lot of my colleagues and fellow students did, but I needed to work. I needed to have an actual job.
Yeah,
so I worked in restaurants and, worked in kitchens. And finally an opportunity came up because I would interview for jobs in offices and they'd say, you have no office experience.
Yeah.
I thought, well, how am I ever going to get it? I mean, I thought I was I had great grades, but I thought I was destined to go back and work, like for my brother's plumbing company, which I wasn't any good at.
Yeah, that hasn't changed as well. That whole like chicken and egg of like
Yeah.
you need experience, come back when you have experience.
Well, I
How do get
recently
it?
had the opportunity to find a position in our New York office, a summer internship for a young man who was looking exactly to do that. And our firm understands implicitly that issue and gave him a chance, and I'll see him this summer. But so yeah, it was a problem. And then Sullivan and Cromwell had this thing at that time. I'm sure they don't have it anymore, where they have messenger boys. And one
Yeah.
of my college roommates was a messenger at Sullivan and Cromwell in Washington, D.C., which was, they had some disputes, but it was largely a firm that did big SEC filings. And so they had messengers that would do the mail run. And then you would have to run filings physically in paper, like under your arms down to the SEC, and take a taxi, and it was all accounted for because they needed to make sure it got there.
Yeah.
You couldn't, hazard taking something like that on the tube or the metro.
And how old were you then? Like
I was
22?
21, 22. So
Yeah.
it was my last year and a half of college. And we would do our homework in between runs. And, some of the partners would take the time to invest in you. Some were like, thanks, drop it in my inbox and please leave.
Yeah.
But it was a really interesting experience. And I became fascinated with the law firm. I actually wrote my senior thesis on Sullivan Cromwell's involvement in a number of foreign policy developments from the 1900s onwards. Sullivan Cromwell, for instance, was instrumental in the creation of the Panama Canal.
Yeah.
And so, it was a great opportunity. I loved it. I worked with a number of African-American gentlemen that ran the mailroom, and they were all excellent supervisors, really good people. And they provided this incredible landing because, these guys they were like people I grew up with where I grew up in terms of sort of more on the blue collar side, and they got it, and they helped my transition into the white collar world. But even then I thought like ending up with my own office in one of these spaces was well beyond me, even though I was studying to take the LSAT at the time that I worked there. It just seemed beyond touching distance really to go work at a big international law firm like that.
But I can imagine that'd be quite a fun experience because you're not, I guess, the stressful part of the job is, the academic thinking, cognitive side of things, particularly late into the night. I can imagine 21, 22, you're in the mailroom, like 3 or 4 guys, similar age, all in a similar position, like quite a fun experience running around New York.
Blast.
Or Washington, I should say.
Yeah, we spent, I was a student as well. I was a full-time student.
Yeah.
So this was sort of my part-time job. But I spent most of the time talking about the Philadelphia 76ers and Allen Iverson, because who was very big
Basketball?
at the time. Yeah, it was basketball.
Right.
With the guys that I worked with, arguing about that, and rap. We spent a lot of time arguing about who was the best MC. One of the most useless conversations you can have, but it would just go in circles. And it was a great time. And then at the end of it, I would either go to the library to study more, or it'd be like a Thursday or Friday night and we'd go have a party.
Yeah.
So, it was a good job. And I did get to see what it was like. You got to see in particular what the life of a young associate was in these law firms. And I was really glad I had that experience. But it was my first office job for sure.
Yeah. So did the mailroom at Sullivan Cromwell during university, just after university, and then your first actual role post law school. Because I know I don't want to get too far into the weeds of like 1L, 2L, whatever the American system is, but like your first qualified role, where were you?
So, pre-qualification, I actually did a summer associate position in Puerto Rico, of all places.
Wow, right.
And that was a great experience.
That's U.S. territory, isn't
It
it?
was a U.S. territory that is a combination of common and civil law.
Combination of the two.
Yeah. So
Okay.
Puerto Rico is a former Spanish colony.
Yeah.
So Puerto Rican law is civil law.
Yeah.
But I was working in federal courts there, and that's common law.
Oh, so on the state level, it's civil, on the federal
Yes.
level, common.
But issues of, for instance, Puerto Rican property law that you'd have to litigate in the federal courts was civil law.
Yeah.
So it was a fascinating experience working with a
quite
lady who is the president of the Puerto Rican Bar Association, named Selena Romani, who had been my professor in law school, and she hired me. And I didn't speak any Spanish, and she got me an apartment, and I had to figure out how to get the bus to her offices every day without speaking Spanish. But it was, I did do it on my own, and it was great opportunity to sort of practice abroad almost. And so I did that, and then I came out of law school, and I had totally flubbed the process of getting a job. I hope that maybe some of your watchers, your viewers, your listeners can empathize with, I have a great career now, but it was not set up for success because I went to law school because I thought I wanted to practice public interest law. I wanted to be a crusader. And I worked in a legal clinic for 2 years, specifically focused on two things: suing Henry Kissinger for war crimes and working on the repatriation of people to what is the Chagos Air Force Base, which is very much in the news right now.
Chagos,
yes. We were suing the federal courts to repatriate the Chagosians
from Mauritius,
from Mauritius and the Seychelles
to
Diego Garcia, which is what the U.S. calls that Air Force Base.
Yeah.
And I loved working on the case. I hated working in public interest. To me, it was like a church. If you would argue with your colleagues about how we needed to take into account a counter argument that might really have us in the soft underbelly of the case, people would look at you and, I'm not so sure this guy is, part of the cause. They look at you like, they'd be like, well, isn't it our job to take into account these counter arguments? And it was sort of halfway through law school, and I realized I needed to change tack. And I hadn't done on-campus recruitment, which is the big thing if you want to become an associate in a U.S. law firm. So I went and worked in Puerto Rico, and when I graduated, I didn't have a job. So my first job, which I really never put on my LinkedIn profile, was that I was for 6 months, I was an insurance defense litigator for a small law firm in Silver Spring, Maryland.
Yeah.
And so the day I was barred, I was arguing cases in Baltimore and in the coal country of Western Maryland over things like slip and falls.
Yeah.
And I mean it when I say literally I went from barred to arguing in front of judges the next day, and sometimes doing 3 depositions in a day. It was a volume business, and it was tremendous experience in terms of becoming a trial lawyer. You had to learn it. But I knew I didn't want to work in Silver Spring, Maryland. With all respect to Silver Spring, I had bigger aspirations. And an opportunity came up to sort of segue my career by working at a federal appeals court in Atlanta. And it was a position called a staff attorney, which is like doing the work of a clerk, as you guys would say here, a clerk, which has a different meaning in the U.S. It's working for a judge to help them decide appeals and draft their decisions.
Yeah.
But as a staff attorney, you're doing it by volume. So it was this crash course in crisp, clear legal writing, and you had a quota of...
Oh, it was high volume as well.
High volume. You had to churn through judgments and skeleton orders for these judges. I think we had to do... There's going to be some staff attorneys going to catch me out on this, but we had to do like 6 every 2 months or something like that.
Yeah.
Which was quite a lot. I think by the time I finished in 2 years, I think I had done something like 120 appeals.
Yeah.
And I don't want to get too far ahead of myself, but I knew by that point I wanted to work in big law.
Yeah.
So I had planned and I had obtained a job, maybe the last job before the financial crisis in Washington, D.C. And that's when I moved into private practice fulsomely.
Yeah. So which firm did you join to start with?
I started at a great law firm called Crowell and Mooring.
Yeah.
A real Washington, D.C. firm that was an offshoot of Jones Day.
Yeah.
And big in government contracting, but they also were doing a lot of international litigation and international arbitration. And so when I first got there, they hired me specifically because my experience working in the courts and the Kissinger lawsuit was germane to something they were doing, suing Libya and Iran for sponsoring terrorist acts in the 1980s. And we were suing on behalf of victims of those terrorist acts under the Foreign Sovereigns Immunity Act. And it was my job to sort of prosecute those claims with a number of other lawyers on behalf of victims of terrorism and get paid for it.
Yeah.
And it was fascinating work, but eventually it dried up for a number of really good reasons, including that the U.S. government sort of settled a number of the claims, or what we called espoused them. And that's when the international arbitration people started to sort of ask after my time.
Yeah.
And I found myself becoming an international arbitration lawyer in short order.
So that was within the firm then. So Crowell, you had, and they have an office in London, of course.
They
but
do.
At Crowell, you're working on this project. It had a deadline, let's say, or a finish date, and then within that same firm, the international arbitration team, you're just doing more work for them internally, and that's how you got into it.
Yeah, it was this basically, we didn't have as much to do on the terrorism cases,
Yeah.
and a guy named Arif Ali, Bangladeshi, British, American arbitration guru raised at Freshfields, said, "Hey, I heard you can write, and I need your help on a big case involving the most famous hotel in Dublin, the Shelburne, and you're working for me now."
Yeah.
And I had concert tickets that night to see my favorite band, Dinosaur Jr. And I said, well, I'm going to go to the show, but I'll come back afterwards. So at like 11 o'clock, I started working on this stuff, and I didn't sleep for 36 hours.
Yeah. That's a good baptism of fire getting into it then.
Yeah, I mean, it was the reunion show. I wasn't going to miss it. But it was a baptism of fire. And that event specifically led to me moving to the United Kingdom, to London.
So you moved directly from Crowell to the UK?
Yeah. So when I fell in love with international arbitration, I did not fall in love with working 36 straight hours.
Yeah.
And I worked with an Irish barrister who's at Brick Court Chambers here named Klaus Reichert. And Klaus and I hit it off. He is a Kerryman, despite his name being quite German. And my family hails from Kerry in Ireland. And he said, I'm doing a big case in front of the Supreme Court. How would you like to come work with me on that case as a research assistant? And my firm said, great opportunity. There's a bit of a conflict. We're going to let you effectively leave the firm for 6 weeks and come back to us, but go work there. So I slept on a buddy's couch. I worked here in London at the Supreme Court, battled food poisoning, which is a recurrent theme in my international career, and had the time of my life. And during that time, Klaus said to me, you need to be here. You need to be working in London. This is where international arbitration really is at the zenith of its practice. And he helped me get a job at Allen & Overy.
Yeah.
So I had just been married, and my now ex-wife, who's fantastic, said, yeah, I'll move to London with you. We packed up our 2 dogs and we came here, and 15 years later, 2 kids and a divorce. I'm still here. She's still here, and we've got 2 great kids.
Yeah. Amazing. So what was it like moving from Washington to London? I mean, is there a huge difference, or is it similar in some ways? I mean, what's it like from your perspective making that move?
It was different in every possible way. I felt I could do the job, but I felt really out of my depth. I remember just one cute story. I mean, during the training at A&O, the computer trainer kept talking about Fionas and Fiona this and Fiona that. And finally, at one point, I looked at one of my colleagues and said, what's a Fiona? She said, fee earner. We didn't have fee earners in the U.S. Someone used that expression with one of my partners recently, and he had the same reaction, a U.S. partner. You know, in the U.S., we just say lawyer or paralegal. We don't say fee earner. But it was night and day. Allen & Overy, it was like learning to practice all over again. It was totally new structure.
There's different jurisdiction as well. So
different jurisdiction, highly regimented, highly organized. There was an Allen & Overy way of doing a case. Yeah. And I immediately saw, with all respect to my former colleagues, it was a better way of doing cases. And I bought in, and I wanted to learn it. And I adapted very quickly to it. I think some people at A&O might not think that, and I just saw it for what it was. This was a great way to run arbitration cases, learning at sort of the place, along with Freshfields, that really created this sub practice of the law. So it was, I dropped pay by about 2/3.
Yeah.
I was being paid very well in Washington, D.C., but this was before the big pay rises here in London. So we burned through our savings as a couple right away. I mean, it was really, to use your expression, a baptism of fire, and an expensive one, but I would never change it for the world. It was an investment in becoming a very good lawyer.
And yeah, I think the financial side of things is slightly evened out a bit. I mean, it's certainly better than it was. As you said, the remuneration on the lawyer's side of things wasn't nearly what it is today. Maybe slightly inflated, maybe not in some cases, but it's definitely changed from 10, 20 years ago.
Yeah, I mean, I think some would say, oh, well, you Americans came over here and started throwing the cash around. But when this American arrived, they weren't throwing cash around.
You missed it by 10 years or whatever.
I know, and I probably set myself and my ex back years in terms of wealth. But look, I work in big law, but it's never really been about the money for me. It's about enjoying the practice and doing something to the best of my ability, my limited ability. And that retraining, what I call it, was the best thing I ever could have done. And I wasn't even at A&O long, but I still hold it in the highest regard. Allen and Overy is against me in a case now. Sorry, Allen and Overy Sherman. And, I just know we're up against really formidable opposition because of the way that law firm is run.
Yeah. And it comes back to something we spoke about just before we started recording, that as a junior lawyer, putting yourself into those big firms and those big environments where they've had 10, 20, 30 years to get those processes nailed, they're amazing places to learn. And then maybe later in your career, you can sort of branch out and do something else. Particularly now on the financial side of things, most law firms you go to, you're probably going to earn a decent amount of money. But the one thing I think that separates firms at the junior end is training. You can go somewhere, get paid a lot, and come out the other end not necessarily a greatly drilled lawyer. Whereas other firms, you might get paid slightly less, but the training is worth it in the long run.
I couldn't agree more. When we hire now, CVs from firms like that, Allen and Overy, I always place a high regard on Herbert Smith Freehill's CVs for the same reason.
Big litigation.
Yeah, Linklaters. You see those places and you just think, I know this person was trained well.
Yeah.
And that they will have a pretty systemized way of doing something.
Yeah.
And, they know how to be an associate in a law firm. And, that's what I got from that experience too, even though I had been an associate for years.
Yeah, absolutely. So spent some time at A&O. Where did you end up after that? Was that straight to Boies or not?
No. So the two guys that recruited me to Allen and Overy went to Quinn Emanuel, which was really starting to rocket off. I think Quinn had been in London for 3 years at that point. Yeah. And when I joined, there was about, I don't know, I think there was 20 of us in that office at the time. Now I think there are like 120 people.
Yeah.
Again, sort of kismet scenario. That's where I learned the business of law. Totally different scenario, environment rather than Allen and Overy, but a place that really emphasizes getting the big cases and then winning the big cases.
Yeah.
And at Allen and Overy, you're not really taught, with all respect to Allen and Overy, how to go out and get new clients because the firm has its clients. And in fact, if you're in the disputes department there, you going and getting a new client might create a conflict.
Yeah.
At Quinn, you had to go get work. And I remember all of the things that I had been doing that I thought were business development at Allen and Overy, like speaking engagements, posts within umbrella organizations in the world of international arbitration, I quickly was disabused of the notion that those were in any way accretive for business development.
Yeah.
And the quote that is forever etched in my mind was, it came from John Quinn. I don't know if he said it to me or I heard it secondhand, but you can't eat profile. So here I am on a podcast seeking to raise my profile. But in essence, the idea is that you can speak at every conference in the world, but most of your clients don't go to those conferences.
Yeah.
They don't read a lot of those publications. There's so much out there in terms of blog posts, newsletters, podcasts. John Quinn went directly to clients, and that's what I learned. And I didn't make partner at Quinn Emanuel. I ended up leaving to open the office for a Swiss arbitration boutique called LALIVE that wanted to open in London. And they needed someone to do that. I knew the people there at LALIVE, and I was fortunate enough to have the opportunity to, with the management in Geneva, start that office. And I mean everything from ordering on Amazon the dustbins to getting SRA approval to getting insurance to finding premises.
Yeah.
And if I hadn't had the experience I had at Quinn in terms of learning how to develop business, I wouldn't have been able to do much in that LALIVE environment, because we were able to go out and bring in a number of clients, and that office grew precipitously. Again, with the backing of the management in Geneva. Wasn't a one-man show by any stretch. I worked with a number of great partners, fantastic associates, but it was really successful. And then the time came a few years into it where I saw an opportunity to join Boies Schiller Flexner, which at that time had lost pretty much its entire office. Two partners and an associate had been left because everyone had gone to start a boutique.
Yeah.
And if you grow up working in the mailroom of Sullivan Cromwell in the late 90s, early 2000s, when David Boies, the most famous litigator in America, was suing Bill Gates on behalf of the Department of Justice, who was represented by Sullivan Cromwell. And you know that David Boies and co. are looking for someone to come in, sort of right the ship for their London office, and you're an American, grew up in that sort of time and setting, you jump at the chance.
Yeah.
And so I did. I saw that there was a huge opportunity at Boies Schiller Flexner to work for people that founded a law firm that in many ways embodied all of the values that I had developed from all of the experiences, Hugo, that you and I spoke of previously, in terms of having a big firm structure. Boies Schiller Flexner came from Cravath. Having the entrepreneurial spirit bred from a place like Quinn and then at LALIVE, but also having to sort of develop an office culture like I did with the management at LALIVE for the London office. So it was the perfect opportunity for me, and I couldn't pass it up. And it's been 4 very happy years.
Great. So in terms of Boies then, you've touched on it briefly there, but who are they? What are they known for? What are they good at? Where are they based in the world?
Yeah, so Boies Schiller Flexner was founded by 3 people. David Boies, who I just said, America's most famous trial lawyer.
Yeah.
You grow up when I grew up, that's who you want to be. But there's another gentleman who I worked with, and I still work with a lot, named Jonathan Schiller. And Jonathan Schiller was an international arbitration specialist kind of before that existed, doing huge cases in the Philippines and other jurisdictions. And so, funnily enough, I couldn't actually interview with Jonathan when I joined the firm because he was actually sitting as an arbitrator in a case where I had appointed him. So, but I knew of him, and I knew all about his style of hard courtroom litigation advocacy in the arbitration setting. And then it was founded in third by a gentleman who's no longer with us named Don Flexner, who was the titan of the U.S. antitrust competition bar. I never knew Don. He passed away not long after I joined the firm, but David and Jonathan and I have separate relationships now. Jonathan is someone I'm pretty close to. David I've gotten to know. And they founded a law firm where it was disputes only. That's all we do.
Yeah.
You know, I like to say we handle the divorce, not the marriage.
Yeah.
And we look at every case like we're going to take it to trial. And that enables us to get you the best outcome because it enables us to really position you best potentially for settlement.
Yeah.
Something that a lot of international arbitration lawyers don't do is talk about settlement because, you know, your fees go away when you settle a case. But we'd rather settle and get the next one because that's what clients want.
Is that like if you want peace, prepare for war type attitude?
Precisely. You know, if you prepare for trial, that means you have a case theory. You have figured out what, in 3 sentences, your case is about and what you're going to tell, in my case, 3 arbitrators or a arbitrator. And if you can tell that story in those 3 sentences, then it's going to be a lot more persuasive when you have to sit down at the settlement table. And you are just banging on that thesis throughout the entirety of a case. Of course, it might be more complicated than that. But you still have to know what that theory is. And I learned that, you learned that in the US in law school by sort of watching a lot of David Boies' cases. And now I get to do it at his law firm in international arbitration. And it's proven really successful. We've had a lot of big wins. And, you know, I hope there are a lot more to come. But it is a special thing about this law firm. We won't do your contracts, and we we don't have huge clients that we advise on everything they do because we are disputes only. It might be that a client calls us every couple of years. That's the nature of that particular business. But I became a lawyer because I wanted to do courtroom stuff, right? And the idea of working on a transaction, I don't even know why you become a lawyer to do that. So I get to do what I want to do every day in that regard.
Yeah. So in terms of your practice then, international arbitration lawyer with a focus on state investment treaties.
Yeah.
How would you describe your practice area? I mean, what clients do you typically work with? What parts of the world are they based? And what problems do they come to you with?
You know, I have to do this a lot, Hugo, because I'm single. And when women I'm on a date with ask me what I do, I'm like, let me try and nail this. We represent companies that have invested in a foreign country and had that foreign investment interfered with in some arbitrary manner that breaches the state's obligations under a contract or under an international treaty between the host state, the malfeasor here, and the state where the investor is from.
Yeah.
And we sue under those treaties, usually at the World Bank. And those cases, the clients are from all over the place. Most of my clients are Australian, Canadian, English, some American. The cases themselves happen in developing jurisdictions in terms of the facts.
Yeah.
So West Africa, East Africa, Latin America, some Central Europe. Those are the areas where I work the most. But my clients are in Perth, Australia, Toronto, Canada, Vancouver, London. One client in Berlin, which is one of my favorite cities, so it's great to go there.
Yeah, definitely.
And so my practice these days is either, working in front of a computer screen on submissions, preparing for a hearing where I do all of my own advocacy, going to places like Mexico, where I was last week, to look at the site where my client's gold mine was supposed to be, or negotiating directly with governments, where I'll be in East Africa in a couple weeks, sitting down at a table with a government to say, stop doing what you're doing, and we won't all have to end up in a conference room at the World Bank where this all goes to trial. And I should note, ends up on YouTube a lot of the times, because these hearings sometimes require that they're made and done in public. And what that means is that it gets recorded and posted on YouTube. So
I thought one of the benefits of arbitration was the privacy. So if you sue someone in a court, the decision goes public, but if you sue someone in an arbitration which is private, then it stays private. Is there no way to...
So there's two kinds of major arbitration. There's commercial arbitration, two companies suing each other in a neutral forum. That's almost always confidential, although the confidentiality rules change between country. Here it's default. In London and England, default confidentiality.
Yeah.
But when you're suing a state, the treaties themselves tend to dictate the nature of whether it's confidential or not.
Yeah.
Newer generation treaties require openness, as it should. You know, a state has done something usually or not done something, and that requires openness and transparency. Some treaties allow the state or any party to claim confidentiality. One of the ironies of what we do is that the system I work in is frequently attacked by places like The Guardian that say these cases are about, this happens quarterly, I should tell you. These cases are about major international corporations suing developing states in quote unquote secret courtrooms.
Yeah.
Well, my companies are almost all small cap. My clients are almost all small cap companies that have lost their one investment or their one asset. The hearings are meant to be held open and transparently, and the developing states are the ones that opt for confidentiality most of the time because they don't want people to see what they might have gotten up to. And if you ask them why they want it to be confidential, they just say, well, because we can.
Yeah.
But as I said, some of the newer cases, newer treaties, for instance, the treaty between Canada and Tanzania allows for open courtrooms. And so cases that we've done against Tanzania and Peru, those trials are all on YouTube. And if you want to watch paint dry, you can watch me do cross-examination on those in those fora.
Yeah. So it's my understanding that typically there's a dispute around national mineral wealth. So you mentioned a gold mine in Mexico. I'm imagining a group of armed men drive to the mine and essentially say, we now own this mine. So that's where a dispute would raise because it's Mexico's duty to protect that mine, I guess. I mean, how would...
That is a fact pattern in cases that we do handle. I had one very similar to that in Peru. It can be much more complicated than that. It can be, a situation where a state has decided that in essence, they don't want a particular kind of investment, or as we are now dealing in an age of protectionism, they don't want a particular kind of foreign investment.
Yeah.
But they will find ways to coordinate amongst various ministries and administrative agencies to ensure that that doesn't happen.
Yeah.
And it's for you as the advocate to sort of parse apart what actually happened and then bring it together in a persuasive way to say to the tribunal, don't read the official version here. This has clearly been done to stitch up our client.
Yeah.
Sometimes it is as simple as, they wrote the investment out of existence by withdrawing a law, or you're right. A lot of times there will be people with guns who turn up and all of a sudden the police forces are withdrawn and never turn up again to make those people go away.
Yeah.
And that's when you call me.
Yeah. So I actually saw recently, and this is the one thing I still don't really understand about this whole topic, is the enforcement side of things. So you mentioned recently, I think on a mining podcast, I saw some video of you say that, back in the day, you might have warships turning up on your shores to enforce the foreign investors' rights. I appreciate that. Yeah, I mean, how does one enforce rights from abroad?
So these treaties require that when an award is issued, it should be paid. So everyone asks that question. I work with mining companies. All they want to know about is when we get paid. And the truth is that countries pay those awards most of the time. Used to be all the time. Yeah. We're seeing more sort of intransigent behavior from states in that regard. And the current political milieu internationally doesn't show any signs of abating in that respect. But they are required to pay. If they do not pay, there are two treaties. One is called the ICSID Convention. The other is called the New York Convention. that require that that award can be taken to the courts of any jurisdiction and treated as if it was a judgment of a court in that jurisdiction.
Yeah.
And you can enforce against assets, not just in the place that you're suing, but in a third place. So if this country, for instance,
Where they're
owns
based.
airplanes or bank accounts that are used for commercial purposes, you can take that award and say, hey, you owe us $160 million. We're going to slap a sticker on the side of this airplane. Pay up.
Yeah.
And we've had success at showing that we could do that. Our law firm handles these things through the enforcement phase.
Yeah.
And as a consequence, states have paid.
So you're financially reimbursed for the loss, but you don't get the physical thing back. So if it's a physical mine and there are a load of guys there, you don't get the physical mine back, but they will pay you the value of whatever you've agreed in the contract.
Correct. And there's a number of different ways to value that asset. But, courts and arbitral tribunals can give various kinds of relief. One of them is specific performance, making someone do something, right? The tribunals that hear my cases are pretty uncomfortable telling a state to give something back. And usually you're at this for like 3 years, right? So that asset might not even exist at the end of that 3 years. So typically what you're seeking is compensation.
Yeah. Cool. So in terms of your practice area then, I mean, you've touched on some themes there, but I mean, what is an interesting development over the past maybe 10 years or so? Maybe it could be geopolitical. I know that things have been shaken up a little bit more than they have been in the past, but what are clients concerned about at the minute?
Look, one of the great things about practicing in a field like this is that, I grew up skateboarding and surfing, and it's sort of like you're surfing. You have to stay on the board. You have to anticipate changes in the wave, and you've got to navigate these things with dexterity. I was never a good surfer, much better, but even then, not great skateboarder. And it's about adaptability. And what I see now is there's a lot of adaptation that I have to do in terms of the geopolitical order. I find myself now in Abu Dhabi or in parts of Africa where all of a sudden, after multiple years of U.S. backseat involvement, the State Department is turning up saying this asset belongs to someone else, or it should go to someone else, or you are messing around with this investor that has DFC backing or the Department of War, they call it now, financial backing. And the U.S. is being more muscular in terms of its diplomacy with these developing states. I have to adapt to that, either get my client on board with it, find other ways to convince the sovereign that they should work with us, figure out how to impress upon the sovereign what our legal rights are. And then at the same time, because the U.S. is now so throaty about these things, the EU is getting more involved, and the Emirates are getting more involved. So, and China has been an ever-present fixture in this space since as long as I can remember. So you're genuinely seeing the geopolitical race for critical and other precious minerals having a day-to-day impact on how I practice law. And it's a matter of adapting, figuring out the right people to talk to. It's not as simple as writing a good legal brief anymore. And when we as a firm had success in delivering results for clients, we got increasingly hired by clients to go stop problems in their tracks. Well, that requires you to look at the geopolitical context and adapt your client's approach to things. And when you see the U.S. getting involved much more than it ever had under the Biden administration, for instance, even though they had very strong policies with respect to, say, critical minerals, you're now seeing boots on the ground from the U.S. and you've got to adapt to it. So that has been the biggest development, and I've really seen it just in the past 5 months. There was a little bit of a lag time when the administration came in, but it is something that I have to take into account nearly every case.
But makes it a lot more interesting as a lawyer. You know, I've made this joke many times. My football team, or I was going to say, I'll say it, soccer team, for your benefit, is just set the record of the fastest team to be relegated in the football league. So it's like being a goalkeeper for my team. Like, you're always busy. You want
Which team is that?
Sheffield Wednesday.
Yes, I saw that the other day.
Yeah.
Uh,
But you want to be busy. You know, you want things to go wrong so that you can fix them for your clients.
I don't want things to go wrong for my client. I'll put it like, you know, you do get sometimes emotionally invested in these cases because you become close with the client team and you can see the stress that this places them under. And unlike those Guardian articles I referenced earlier, most of the time my clients are not like mustache twirling robber barons that want to sink a state. They care about an investment. They care about the people in the community surrounding it. And when it's threatened, you know, the livelihoods of lots of people are threatened. So you have to empathize with that, but you also have to remain slightly objective. But my philosophy is always help someone earnestly solve that problem. And it might not mean a lot of fees for us as a law firm, but if you help them, they're going to tell their friends that I can help them as well. Yeah. And so that's the philosophy. I mean, being busy is good. You'll be a much better keeper for Sheffield Wednesday if you're facing lots of shots. But I'm an Arsenal supporter, so we don't really have that problem. A lot of clean sheets this season.
Right. Yeah, easy for some. So yeah, I mean, you touched on some business development at Quinn, learning how to do business development really well that goes beyond newsletters. How do you build relationships? How do you maintain relationships? You mentioned there doing people favors that aren't necessarily in the best commercial interest, but will have long-term benefits down the line. What's your philosophy around winning and maintaining business?
So your viewers should all go read How to Win Friends and Influence People. It is an old-timey book that uses a lot of old-timey language, but it changed my life. And I'm a voracious reader. I never thought that something that sounds like a really corny self-help book would be a book that changed my life. You know, I thought that would be The Book of Laughter and Forgetting by Milan Kundera, but it has. That book will teach you the art of building a relationship for the sake of building a relationship. Yeah. And when you build that relationship earnestly, you build a relationship that will benefit you. The benefit follows from the desire to earnestly be interested in what the other person is saying. And that is sort of the key takeaway of that book, is listen to someone and genuinely be interested in what they're saying. And if you can do that with clients that you're working with, say as an associate on day one, you'll learn from them, you'll develop that relationship over time, and they will remember you, particularly if you do a good job for them. So my philosophy is always do sort of the next right thing in terms of working with clients to preserve their interests. Sometimes that can be tested. Some clients, you might do really good work for them and they want to dispute your bill, even though you earnestly spent all that time on it. And you've got to be tough and say, well, we can do something, but ultimately we did spend this time on it and you asked us to. But, you know, I think that reaching out to them directly, not being afraid to say, this is who I am and this is what I'm capable of doing and I can help you, is the first step. Obviously, we talked about training. You should learn to be a good lawyer and you should get good training. I'm sure some people at A&O are like, I wasn't a great lawyer, but learn to do the job. Then you have something to sell to these people, but you sell it by saying, I can help you and I believe in my service. My service is me and the team that I work with. Not always the brand of the law firm, but you and your capabilities. And then when you do that, you cannot be afraid of these folks telling you, am I allowed to curse on this podcast?
Go ahead, yeah.
Telling you to fuck off.
Yeah.
They might never write you back. They might write you back something nasty. I've had clients of mine, some of my best clients ghosted me for years.
Yeah.
I had some that did tell me to get lost. And now those are really deep relationships. Don't take it personally. Just believe that you have learned the skills that you can then deploy to be helpful to someone. Master those skills and then go apply those services. And if someone doesn't come back to you, then it's not the end of the world. They might come back eventually, or someone will, but you can't be afraid to do it because they'll never get the business in the first place.
Particularly as a lawyer as well, you can't. Sorry, as a disputes lawyer, you can't really be transactional. So let's say there's 100 oil and gas companies out there. Maybe 2 or 3 will be in a dispute every year. That's obviously these numbers are wildly inaccurate, but as an example. But if you build relationships with 100, knowing that they're not going to be buying for 2-3 years, when they do buy, you'll have that relationship already. So it's not always about looking at in the news who's already in a dispute.
That is something I see associates do all the time. I'll get an article from one of them. So and so's in a dispute, and I thought
Too late. It's
yeah,
too late.
I mean, they've had lawyers for years now.
Yeah.
That thing, but you don't need to talk to these folks about something that's already happened. You just need to form a relationship.
Yeah.
I mean, I get told when I meet clients, or new prospective clients, very frequently, Tim, I hope I never see you again. And you think, well, I get it, but when there's a rainy day, you'll wish that you knew me. But when you meet them, try to develop a relationship as per Dale Carnegie said in his book. I mean, I met someone yesterday and we realized that we had some people we knew in common. We realized that we were the same age, that he went to high school in an area where our law firm was founded in Westchester, New York. We knew some of the same people through that and some of the same towns, and it's about building a connection.
Yeah.
And that gentleman has no work for me right now. I can tell you that, but he might remember me down the road, and I'll stay in touch with him in the meantime.
Yeah.
I also have to just go back and emphasize something that I said before, because I've met a number of younger lawyers that want to learn those tricks of business development, but they haven't learned how to be a good lawyer yet. And they get so exhausted when I say to them, no, it's your time to like stay in the trenches and draft the briefs. And they'll say like, oh yeah, you always say that, but like, how do I do it? I'm like, well, you have to have something to sell. If you're not a good sort of trial lawyer yet or arbitration practitioner yet, then what do you have to sell?
Yeah.
You know, how can you go tell someone that you can win a case for them if you've never done a cross-examination in international arbitration?
Yeah.
You can't.
And also there's
there's no fake it till you make it with this stuff, right?
You get found out very quickly. Particularly reputationally, everybody talks. And also being a junior associate, I think you have to be age bracketed in your age. You know, if I was a 23-year-old associate and there's a GC in their 50s, maybe it's difficult to build an authentic relationship, but you can start building relationships early on with people of your own age group. In 20 years' time, you know, so that a quote from somebody else said, you know, one day you're down the pub, you think these guys are a load of wasters, and you wake up 20 years later and is the general counsel of, you know, Facebook or whatever it may be.
I couldn't agree more. I mean, two responses to that and stories. I mean, literally, I was running over here because I wanted to meet with one of our associates about exactly that. And I said to her, hey, listen, you have all the makings of a partner at this law firm. It's time that we start talking about how you can build a profile and develop business contacts. And we talked about setting up an event where she and our other associates will do something with the in-house counsel of their vintage, right? We did this once at Quinn Emanuel. We did the Crystal Maze together, you know? And so the idea is that she and other folks of their sort of 4PQE will get together and they'll take those folks out. In terms of the wasters down at the pub, I mean, one of my closest clients these days is a guy that I played college club lacrosse with, who, you know, I'm sure this guy thought I was, you know, an asshole. I loved him, but I would scream at him from the lacrosse field sometimes.
Yeah.
Well, now he's in-house at a very big Connecticut-based fund. And, I just stayed in touch with him. And something came up that was right for us. And a relationship that had effectively been dormant for 20 years was completely rekindled.
Yeah.
What I love about that is that when that guy and I talk to each other, it's like we're back on the lacrosse field 20 years ago. There's no, it doesn't matter what great stuff he's gone on to do, and he's done great stuff.
Yeah.
And it doesn't matter whatever stuff I've done, that relationship is set in 2002.
Yeah. Yeah. That's amazing to hear. I think there's no shortcuts, and everybody wants a shortcut answer. But the reality of the situation is it takes years to build. So, as a 2-3 PQE associate, unless you, start your own law firm and do, contracts for crypto firms, starting your own thing, you really have to earn the right to be able to do that. Number one, being a very good lawyer, and number two, building a reputation and relationships over time.
I agree. But, also you need to be in a place where when it comes time to segue into becoming an owner of the business, the business is going to show you how.
Yeah.
That is something that I think sets us apart at Boies Schiller Flexner, is that when we hire someone, I'm very quick to say to them, look, the time will come where you are asked, okay, what's your business case for partnership? And a lot of law firms, you're not having that discussion until you're like 8 years qualified, 7 years qualified, and you're just expected to know. Well, and I was sort of like that. And I had looked at how John Quinn had built the business at Quinn. I was like, well, I'm going to try and figure that out and do what John did there, obviously on a much, much smaller scale. And I tell recruits that I will teach them how to do that, because no one tries to teach them how to develop their own businesses. And what you and I were speaking about before we recorded is when you build your own book of business, the key there is a certain sense of autonomy. Yeah. You are no longer just sort of working just for the people who run your law firm, although you still are. I still work for David Boies. I still work for Matt Schwartz, Sigrid McCauley, the other people that manage our law firm, Jonathan Schiller. But my schedule, my life is dictated more by my clients than it is by the strictures of the law firm itself. And that autonomy allows me to be a fantastic co-parent with my ex-wife, for instance, and get to
skateboarding in Portugal,
or last week in Mexico, or in a couple of weeks in Australia, and get to go away with my children, take my children on business trips.
Yeah.
Where I have a client, a guy named Andrew Dinning, who I said, well, we need to have a meeting in Perth. And he said, well, yeah, bring the boys. They can have brunch while we talk business. That is, what a great life.
Yeah.
What a great life to be able to spend time with my children in that way. And that comes from having created the autonomy by learning how to develop business.
Yeah, absolutely. So as a rounding off section then, what would be your advice for your trainee self or for trainees today?
What I would say is you have to learn your craft. And I know that in the day of AI, it's really difficult to understand what that means.
Yeah.
I was talking to my sons about this on the walk to school today. They had been doing some research on irrigation, and they're twins. And they clicked on they Googled some things, and they get the AI answers. And the AI basically gives them the answers, but it doesn't create, obviously, a deeper understanding of the subject matter. And that was essential to learning what I did. I mean, when a partner at Allen & Overy said, you better learn English contract law, I didn't just go get the answers to the issues in that case. I read Chitty, effectively cover to cover, because I needed to know. I wanted to understand, and I wanted to be able to apply that knowledge. And so you have to become knowledgeable about the law and about drafting. You have to become a good drafter first. Then you have to be a good student of your clients' businesses. and learn those businesses inside and out so that you can then apply the law and the facts properly to advocate their case. And what you will learn in that period of time is that you are constantly mastering a subject only to put it down again.
Yeah.
So the minute you're a good drafter, you become a supervisor of other people drafting.
Yeah.
The minute you're good at disclosure, you're not the one reviewing documents anymore. But if you learn the adaptability of learning other people's businesses, you will always be able to be ready for that next challenge. And the other day I was on a train and I was just marveling at the fact that to be a successful autonomous law partner, you have to have the right balance. I mean, to the extent that I am, I should emphasize, you have to have a balance of being pretty good at a lot of different things, some of which have next to nothing to do with law books and the understanding of the law. But coordination, team management, HR, empathy, all of those sorts of things. And you're never going to be great at any one of them. I'm not great at most of them. But you have to be able to recognize that it's not just the one thing. And so the young lawyer, myself included, thought I just needed to be the best at drafting and understanding the law and applying the law. Okay? That's the case for maybe 5 or 6 years, but then you'll have to move on to other things. I wonder how many people would go to law school desiring to be in private practice if they knew that to be successful as a partner would require a word my sister used to love to use all the time, a melange of all those different aspects.
Yeah. I think there's definitely a bit of a disconnect there. I mean, I said when I was at law school, I thought a lawyer did black letter law. There was no sales at all involved with that. Again, it's quite a naive thing to be thinking, but nobody really talks about it, I don't think. There's a big drive for commercial awareness, but for most people, that's quite an abstract concept. I think people have a broad understanding that partners bring in business, but even for junior associates, it's quite difficult to imagine what that looks like in practice. So for a law student, it's Chinese.
Oh yeah, and law firms would bring these business development gurus in to talk to you about how to do it.
Yeah.
And they'd have great tips, but the fundamental aspect of who is the client that you would develop such a relationship with in the first place, particularly when you don't have any form of specialism and very little experience, that's never something they're going to be able to teach you. That has to happen organically. And as you said, it's more likely to happen with somebody who's sort of your contemporary.
Yeah.
So sometimes you have to go meet that person and be like, so what do you do all day? And how do I get to understand that?
Yeah.
And I don't drink anymore, but you might take them to the pub, just pump them full of information, buy him or her some pints or a glass of wine and get to know what they do.
Yeah.
They'll remember that interest.
Yeah.
But being a lawyer at age 46 bears almost no resemblance to what it did at 26.
Yeah. And finally then, so what's coming up with you? What have you got going on either personally or professionally?
Yeah. A lot of business travel. I'll find myself in Tanzania and Australia in the coming weeks. But the thing I'm most excited about is that I think my sons and I are going to do some camping in some U.S. national parks this summer.
Nice.
And they are signed up to go to the skateboard camp that I went to as a teen in rural Pennsylvania. And I wish I could sign up with them.
Yeah.
So that's, we have some other trips to plan as well, but I don't recommend divorce to any of your viewers. It's a terrifying experience, but I get to have this incredible relationship with my sons where I have a great professional and fulfilling professional life. But, one of the more exciting things is what am I going to do with these kids during their extended Easter break and working with their mom to figure out something that involves seeing family and having some adventure while I work, and fitting it all in. And that gives life a very makes it a very rich tapestry, I should say.
Keeps it interesting.
Yeah.
Amazing. Well, look, Tim, thanks very much for
Thanks.
your time, and thanks for joining me today.
Thanks so much for having me, Hugo.